Good afternoon, ladies and gentlemen. My name is Noel Hebron-Logan, a final honors 2 student of Rabe College, University of Sierra Leone, in the Department of Law. My responsibility this afternoon is to bring to the fore another helping video on criminal law under one of its sub-preliminary topic known as criminal liability. My previous video was on criminal law itself and crime, and this one will be on criminal responsibility. When we talk about criminal responsibilities, these are crimes that are committed by individuals in society. And those crimes were put together as a check and balance on the conduct of citizens in order to obey the rules and regulations of their states. So in a breach of that responsibility, it could be considered as criminal. So an individual or citizen has a sole responsibility to follow the laws of the state by making sure that criminal responsibility will not be imputed on that said person. But however, when we talk about criminal responsibility, two major elements are necessary to determine whether a crime has been committed or a criminal responsibility has been imputed. That has to do with the two major elements which has been in existence for over decades. That has to do with mens rea and actus reus. When we talk about mens rea is the mental capacity of committing a crime. At the material time the individual is committing or is at the verge of committing a crime, the law is more meticulous of evaluating his mental capacity to know whether his mental capacity was accurate at the material time that crime is being committed. The next one will be actus reus. Actus reus, when we talk about actus reus, is the act itself, the physical act, the physical elements of the said conduct. So if you kill an individual and the individual dies, automatically the actus reus is committed. So for criminal offense or criminal liability or responsibility to be imputed, then those two major elements, both mens rea and actus reus, must be present for an individual to be considered criminally liable. But without such an absence of one, where the act is done but without the requisite mens rea, then therefore the individual may escape liability by law. This had been a lot of argument with the law with regards mens rea and actus reus. There are people, their mens reas are accurate and their acts or conducts are committed, but there had always been a valid defense. The aspect of the valid defense became a game changer. It became a unifier. It became a modifier. It became a transformer to the law of criminal responsibility, where actus reus and mens rea had been considered alone. But the presence of a valid defense in the 21st century has now become a defense. Even where the mens rea and the actus reus are equal, but where there is a valid defense, then that individual might not be criminally liable. Now, let me contextualize this. When we talk about actus reus and mens rea, you have a son. You sent that son to school to be educated. He does his own part of the assignment, and when he is being driven from school for fees, you don't pay the fees. You spend your money on women or you spend your money on material things without fulfilling your own responsibility, which you have ordered your child to go to school. And at this junction, the child decides to steal the said money from you to pay his fees. In this part, of course, there is a valid defense, even where you try to prosecute that child. The mens rea at the material time that money was stolen was accurate. The act of stealing was in place, but the valid defense for him stealing the money from you to pay fees is a valid defense because you are criminally responsible for the said conduct of that child. It would have been an omission. That will be the next topic I will treat for criminal law. Omission, meaning when you omit, failure to act, failure to follow your responsibilities, criminal responsibility will be imputed on you. If you send your child to school, you should pay the fees, you should pay the cost. You should not allow that child to suffer as a result of your own negligence. You should make sure that you pay all necessary costs to see that he gets what you intended for him, which is the education. So even where that child steals to buy pamphlets or to buy books to pursue his education or to pay his fees, you decide to take a criminal action against him, you might fail for lack of your responsibility, because omission will hold you to ransom, which is as well one of the criminal responsibility. Yeah. Now, criminal responsibility, as it has been explained, mens rea and actus reus had been in place, but the valid defense had actually quashed the harshness of both mens rea and actus reus. Where there is a valid defense, the individual might escape liability. We all know, on the part of mens rea, for criminal responsibility, there is this Latin maxim which says, actus facitium nisi mensit re. An act alone cannot hold a man liable except done with a guilty mind. So it's saying that the mens rea and the actus reus could be present for a criminal liability to be considered. But without the mens rea or neither the actus reus, then criminal liability could not be imputed as per the legal maxim which has been explained in this video. Actus facit reum nisi mensit re, which means an act alone cannot hold a man liable except done with a guilty mind. Now, the said Latin has actually been created as the main source of criminal responsibility. But however, I would like to bring to the fore another legal maxim which has actually brought to the fore the reformation of the said of these actus facitium nisi mensit re. An act alone cannot hold a man liable except one with a guilty mind. So the unifier of this said Latin for mens rea and actus reus is now known as actus me invito factus non men est actus, which says any involuntary act, an act that is done involuntarily, cannot constitute a criminal responsibility. If an individual does an act without having total control of his emotion, without having total control of himself, by an involuntary means, meaning criminal liability cannot be imputed. That is what the Latin maxim is saying. Actus me invito factus non men est actus. Any involuntary act of an individual cannot constitute a mens rea, so that individual might escape liability. Finally, this could be a synopsis of criminal responsibility for proper justification. We saw criminal responsibility when we have R.V. White, a locus classicus as well. This was a child whose mother had money, was very rich, but he wanted his mother to die so that he can inherit his mother's wealth. So one day he decided to put a potassium cyanide, which is a poison, in his mother's drink so that his mother could drink and die. But unfortunately for him, his mother drank the said drink, but didn't die out of the poisoning. He died out of heart attack. But he was brought for justice for an attempted murder. He was convicted for an attempted murder. The mens rea and actus reus was accurate. But however, he was convicted for an attempted murder. So I would like all and sundry to understand that criminal responsibility can only be considered where the two elements, mens rea and actus reus, are in place. But in situations where mens rea and actus reus are in place, where there is a valid defense, the individual may escape liability. As per the legal maxim, actus me invicto factus, non mene est actus. Any involuntary act cannot constitute a valid mens rea. So therefore, that individual may escape liability. Thanks very much for your listening as you await the next video on omission.